We will be starting with Muslim law. Personal law, we are having Hindu law, Muslim law separately. Okay. But we'll start with Muslim law because Muslim law is not codified. Okay. There is no specific act, Muslim law act ledu. So there is Hindu inheritance, Hindu marriage, all those things are there. But specifically Muslim, there is no act. So that is the reason there are a lot of concepts, there are a lot of things, and we are not used to those terms. Okay, it may carry 2 marks only. Muslim law nunchi only you may expect 2 questions, but it is very important. Every mark is important. Okay, so that is the reason I thought we will do sessions where concept based topics only for this session, and another session will finish. If required, we will do another session. Last week we'll do 2 at least practice sessions. Okay. So this on here we will do not weekly once kadu, we can do more than one session also. Okay. So what is Muslim law? So see, why separate personal laws? See, there should be some reason. There is no specific thing like all other laws are same for entire country. But personal laws, there are different personal laws based on the religion they practice. So earlier, there was opinion that they should have a uniform civil code. But after independence, because of lot of different communities, they thought let India stabilize for some time. Then over the period, they can bring in uniform civil code. So it is incorporated in Directorate Principles of State Policy, DSP also, that we have to bring in uniform civil code, but it is not happening. So we have to see whether it will happen or not. But as of now, we are following 2 different laws. That is for let me tell you one thing, 3 different laws for personal laws. One is Muslim, one is Hindu. Then there is Indian Marriage Act. So that is separate, where for Christians and others who want to go through that, they can go through Indian Marriage Act. Okay. So in your 25 books, you don't have that Indian Marriage Act. So if you can get hold of Indian Marriage Act books, so you try to buy one Indian Marriage Act bare act also. You may get 1 or 2 questions. Maybe possibility is there. You may get questions from Indian Marriage Acts. Okay. Indian divorce and marriages are from that Indian Marriage Act only. There is separate bare act, you will get it. Okay. So for personal laws, the why personal law separate means personal law, it is only related to Sir, please mute your phone. So personal law, it is basically for marriages, for divorces, inheritance, succession, adoption, guardianship. For these purposes, there is a separate personal law because each religion have their own way of practicing marriages, for performing marriages or getting divorce and inheriting of property. Muslims, they inherit property different way. Hindus inherit property different way. So succession is also similar. There is a slightly difference in succession also. Adoption laws are also different for Muslims and Hindus. So basically, since it is religion based, so they thought that there should be separate personal laws for both. So that is the reason there are 2 personal laws. As of now, Hindu and Muslim both are major laws, and we are having separate law for Indian Marriage Act is also there separately. Okay. So basically in 1956, Hindu Marriage Act, Hindu Succession Act, Hindu Adoption Act, and Guardianship Act, all those things have come. So Muslim law, we are talking, Muslim law is based on Sharia. Okay. What is that Sharia? It is a Muslim law is called Sharia. Okay. Then it is primarily uncodified. See, I'm not a authority on this Muslim law. I made these slides using certain help. So if there is anything, somebody can correct me also. Okay, in this particular topics. So it is primarily uncodified and is based on the principle of Sharia. Okay, it governs areas like marriage, divorce, inheritance, and gifts. It is applicable for all peoples who prefer Islam religion. Okay, this is for people who prefer Islam as religion, and it is developed from 8 sources. Okay, the Muslim law is developed. This is important question. I am sharing only important slides. Okay, so this is from 8 sources. That is Quran. Okay, then Sunnah, then Ijma, Qiyas, customs, justice. Okay, I will correct it. Justice. Okay, justice, equality, and good conscience. Okay, then judicial decisions. See, judicial decisions are like what is that case? That case is there, right? Saira Banu. Okay, Saira Banu case is judicial decision only. Okay, so certain precedents are there. Okay, then legislations. Okay, legislation is also one such. Whenever it is required, legislations are passed. Like triple talaq is one of the legislation, recent legislation in Muslim laws. Okay, so we told that there are 3 different sources of Muslim law, right? So one is Quran. So Quran is this is the holy book, considered direct and literal word of the God. It is coming directly from the God, and it is heard by the Prophet, and it is a fundamental source of Muslim law. Okay, so he heard directly from the God, and he is preached in his whatever he is preaching, what he told that it is the words of God, it is Quran. Then next is Sunnah. Remember this, okay? Sunnah, and it is also called Hadith. This is the second source. So whatever God told is Quran. Whatever practiced by Prophet, okay, whatever he preached, whatever he practiced in his lifetime is Sunnah. You got it? He gave certain judgments. See, some people will come for judgment. He will give some judgment. Then he will give some directions. Okay, you have to do marriage this way, or you have to perform this activity this way. So he followed some practices. He gave some judgments, and he practiced for own purposes. He practiced some things. So from those practices, some source of law is derived, that is Sunnah. Second is Sunnah. Okay. First is Quran. Whatever God told is Quran. Then whatever Prophet practiced is Sunnah. This is the source of law. Okay. And the third one is Ijma. So Ijma is people, scholars who were reading Quran and other preachings, who heard about all those things. They are scholars. Okay. They agreed on certain principles. Okay. This is the law we should follow. Okay. This is the law we have to follow. So these scholars or jurists, they have finalized certain laws. Okay. That is Ijma. It is nothing to do with what God said, or it is nothing to do with what Prophet was practicing. It is reading of Quran. These people understood. Seeing practices of Muhammad, they have understood, and in their belief, whatever they feel that it is good for Muslims, they collectively decided and implemented this certain laws. That is Ijma. Okay. Then the fourth one is Qiyas. Okay. Qiyas is so this is also reasoning and principles of Quran, Sunnah, and Ijma only. So this is based on that one. This is only scholars. Okay, this is not based on that one. What I told, this is derived only the scholars. They have decided which is good for Muslims. It is Ijma. Okay, it is on consensus. Qiyas is interpretation on Sunnah and Quran. Okay, Qiyas is interpretation of Quran and Sunnah by the scholars. This is scholars and jurists. They have decided the Ijma. Okay, these are the main 4 sources. Then there will be other sources, okay, like customary source, where certain customs are accepted. Okay, that is one of the major source of Muslim law. Then, as I told, judicial precedences where certain judgments are given, those things are also used, and practices in certain regions. Okay, so these are basic things for sources of Muslim law. So there are certain schools of Muslim law. Okay, I'm trying to find the notes where so I thought I should not go wrong. Okay, I cannot find. Let me see. Okay, see, schools of Muslim law is Hanafi, Maliki, Shafi, Hanbali. Okay, so Hanafi is majority in India follow Hanafi. Okay, Hanafi school. Okay, this is school is nothing but there are certain practices which this school use. Maliki use certain other practices, customs, and Shafi uses other, Hanabali uses certain other things. Okay, each have certain changes will be there in each school of thought. Okay, basically regarding marriage, regarding divorce, regarding those things. So there will be certain minor changes will be there. So Hanafi is more liberal in interpretation. Okay, so majority in India follows Hanafi, relies heavily on Qiyas. Okay, so it relies heavily on Qiyas, and Qiyas is based on Quran and Sunnah, right? Was what we told. Then it is more liberal interpretation. So Maliki is emphasized on Sunnah. Here it is Qiyas, there it is Sunnah. Okay, practices of Prophet and the customs of people of Medina. Okay, this is basically people of Medina practices. It is Maliki. Shafi focuses more on Ijma. Okay, then Hanabali is strict school adhering to literal interpretation of Quran and Hadith. So it is purely literal interpretation of Hanabali and Hadith is Hanabali. Okay. Then there are certain small things like Itna Akshari. They are called pillars. The largest Shia school. This is followed by Shias. Then there are Ismailis also there. This is also one of the small sect. This is also followed in India. Okay. Then there is another thing called Zaidi. This is another sect. They follow Zaidi sect. Okay, Zaidi law. Okay. So see, Ismailis are there, Zaidis are there, then Shias are there. So they follow different. This is for Sunni, Hanafi, Maliki, Shafi, Hanbali is for mostly followed by Sunnis. Okay, Ashari is followed by Shia. So I'll share this note. So you have to remember. Hanafi is followed by Shia, Sunni, Ismaili. They may ask such questions. Okay, so you try to remember these things. So there are certain differences between Shia and Sunni. Shia is the other, after Sunni in India, let us say around 80-85% are Sunni, around 10 to 15% are Shias. Okay, majority in worldwide also 10 to 15% only constitute Shias. Okay, Shias are mostly concentrated on Iran and few are in Iraq, and most of the other countries they are Sunnis only. So in India also 10 to 15% of the Muslims are Shias. So in Sunni law, muta marriage is void. It is valid in, we'll talk about muta marriage later. So it is valid. Talaq, oral or written, no witness is required in Sunni. Must be, it requires two male witnesses. You please understand, two male witnesses is required in Shia. So if there is no male witnesses, one male witness must be there. Second male witness, they can have two female witnesses in such cases. Okay, inheritance also there is a separate thing. Agnates are preferred, wider group of residuary, all heirs, male or females, inherit together. So here only males are inherited, here females are inherited. Wills 1/3 to a non-heir. maximum one-third be care, can be made to an hair without consent of the others. Okay. Here consent is required. Here consent is not required. When you are giving one-third of your property to outside your out of, he is not illegal here, but you are giving it outside your family. Consent is required in the Sunni law. Shia law, it is not required consent. Okay. So marriage is very important. This is a main primary thing in Muslim law. Okay. Marriage or nikah. Okay. What are the essentials? Under Muslim law, marriage is a civil contract. It is not a sacrament like Hindu marriage. Okay. Hindu marriage, it is a sacrament. It is a performance. It is a ritual. But in Muslim law, you try to understand this very well, because when you understand this concept, it will be easy for you to interpret various other things also. So Muslim law, it is a civil contract. Okay. Its primary object is to legalize sexual relationship between husband and wife and to legitimize children. That is the purpose, objective of marriage, nikah. Okay. So what are the things included? There should be offer. Okay. What is that? Offer should be there. In a contract we heard, right? There should be an offer, ijab. It is called ijab. Okay. Then there should be acceptance, kubul. What is that? Kubul. The other party must accept that offer. Okay. Then there should be consideration. Legal we are talking about contract terms. Valid contract. What are the requirements? Okay. Meher or dower to be paid from boy side to the girl. Dower, don't take it as dowry. It is dower or meher. It should be paid. Okay. Then there should be a free consent. Free consent from both boy and girl. So they will ask, that is what kubul. Okay, are you willing to accept? Then they say kubul. That is the thing. So free consent should be there. Single meeting. Both offer and acceptance must occur at the same time and same place. Okay, so you give an offer that I am marrying you. You say, yes, I am accepting it. It should happen. Okay, you are giving offer. Unlike contract, this is not there. You send a letter, then they will send an acceptance that is there in contract. But here it should happen in a single meeting. You offer at the same time, and the acceptance also should come in the same time. Single meeting. So witnesses should be there. In Sunni, 2 males or 1 male plus 2 females. Shia, no witness required for the marriage. Okay. They execute a document called Nikah as proof of marriage. What is that? Nikah. They execute a document. See, document is also written document is there. They execute a document called Nikah. Then capacity. Both parties must be sound mind and have attained the age of puberty. Okay, they should have attained the age of puberty, and both parties should have a sound mind or to be represented by a guardian. Okay. Say there are a few more criteria. A Muslim male cannot have more than 4 wives at a time. So a Muslim can marry 4, he can have 4 wives, or he can marry 4 times. Okay, 4 times means same time. He can have 4 wives. Let us take that way. A 5th marriage is irregular. It is not void, but it is irregular. There is certain thing called valid and invalid or irregular. Okay, so it is not invalid or it is not void. It is not valid, but it is an irregular marriage. Irregular marriage is called fasid. See, this is another important term. Remember this. Fasid is called irregular marriage. So it becomes valid only if one of the existing 4 marriages, the previous 4 marriages, one of them get dissolved by divorce or through death. One should get dissolved. Then this 5th marriage will become a valid immediately. Okay. So, but same thing, women cannot have more than 1 husband. Okay. Marriage is prohibited in the direct line of blood relationship. Consanguinity. I explained what is consanguinity in the below here. Okay. Direct mother, father, son, daughter, brother, grandfather, grandmother, grandson. So father cannot marry daughter, or some cannot marry mother, his mother. Okay. Then the son cannot marry his mother, something like that. Okay. Daughter, brother, grandmother, all these things are consanguinities relationship. So these things are void. Okay. Then it is called void marriage is called batil. See, irregular marriage is called fasid. Void marriage is called batil. So you remember these things. Irregular marriage, void marriage. Okay, those terms are very important. So such marriages are void under Muslim law. Women cannot marry during iddat period. I explained about iddat period separately. So they can, if the marriage is during iddat period, then it is irregular marriage. Then foster age. So foster age means if a woman gives milk to somebody, not her child. So child is consanguinity, but third party, any not his child, even for one time, then that person is also becoming as a family person only to her. So her direct siblings cannot marry, children cannot marry such child. So woman giving her milk to another child, it is called forced marriage. So those things is also prohibited. Okay. So there are, as I told, there will be three types of marriage. Valid, sahi, sahi hai bolte na, sahi. Okay. Valid marriage is sahi marriage. All legal conditions are met. The marriage is fully valid and all rights and obligations are established. Meher, inheritance, everything is established in valid marriage. So this thing is very important. Inheritance and meher, these things are established in valid marriage. Void, it is not void. Okay. So it creates no rights or obligation. Children are illegitimate here. Hindu law is different. Illegitimate children also get property rights. In Muslim law, they don't get for void marriages. Okay. Irregular, fasid. Irregular marriage is fasid. So this is basically a Sunni concept. Shias don't have irregular marriage. It is valid marriage or a void marriage. But Sunni have, so in, if you are a Shia, you are marrying for the fifth time, it is void marriage. But if you are Sunni, if you are marrying for the fifth time, it is irregular marriage. If one wife is, you divorce the one wife, then it is it becomes valid. So the marriage has a defect that can be removed. Okay. So if there is no witness in Sunni marriage, you can get a witness and take signature later. If there is no, if there is a fifth wife, what I was telling, you can get them. And children of irregular marriage are legitimate. Okay, irregular marriage children or marriage is irregular, but children are legitimate children. So this is one important concept. You may get questions on this type of these things. There is a muta marriage. Okay, this is only for Shias. Okay, Shia law recognizes two types of marriage, that is regular marriage, that is permanent marriage, and muta, that is temporary marriage. So Sunni doesn't have this thing, only Shia have this. So a Shia male may contract a muta marriage. It is a temporary contract. Okay, muta marriage is a contract. As I told, marriage is a contract. So he can contract a muta marriage with a woman professing the Mohammedan, Christian, or Jewish religion. See, Mohammedan law, Christianity, Jewish, all roots are same. Okay, it has come from same ancestry, and prophets are in the line of them. So they have accepted a marriage with Mohammedan, Christian, or Jewish religion also, or even with a woman who is a worshipper, but not woman of any other religion except this religion, or woman fire worshipper. He cannot marry other women. Okay, Hindu or Sikh, somebody, Jain, whatever it is, Chinese. So he cannot marry women of other religion, but he can marry somebody under muta marriage. So what does muta implies is enjoyment or use. It is a marriage for pleasure. It is for a temporary but a fixed period after specifying the dower. So it is purely for temporary, 1 year, 2 years contract. Muta marriage is for enjoyment. Normally, when people are going for war, so they go for years together, 5 years, 10 years on the war, because it was not so easy in those days to, if say, let us say, Aurangzeb, Alexander coming to India. So till India he has come. and going back, it will take 10 years for them from the time they start and go back. So in between, they marry, okay, for 6 months, 3 months, 2 months. So after that, they start going to new place. So they will say this marriage is only for 1 month. So they give dower, whatever it is there. So they want to make that marriage legal marriage. So that is the reason they contract it as a muta marriage. Then they go to some other place. Again, they will marry. There is no limit for muta marriages. You can marry 100 people also. So that is for, because it is for a specific period. After the period, the marriage is automatically dissolved. Okay. So that is specific period. After that period, it will come to an end. So dower, what does dower mean? Specific. There are two types of dower. Okay. Specified dower, okay, mahar, you can call mahar also. It is prompt, payable on demand by the wife at any time. Wife can ask. It is specified mahar, prompt. So wife will ask, I want my dower. So husband has to pay. It can be after 1 month, 1 year, 2 years, 3 years. She can ask at any time. They has to pay that. Deferred, payable only upon the dissolution of marriage. Some cases, if it is deferred, dower is paid when divorce is given. That is dissolution of the marriage. That is talaq. Okay. Or even in case of death. Okay. That is at the time they give dower. Okay. Then unspecified meher. So if no meher is fixed, the wife is still entitled for dower. The court decides, or their preachers or their religious elders will decide on the based on the status of the family of the wife. Okay, if there is not specified, but she is entitled for dower. So some certain marriages, they will not specify what is the dower, but they will say that they will give the dower. So at the time of dissolution, she has to get the dower. So it will be based on the family status and the income. Okay. So then another is called divorce. There is other thing. Okay. So the different types of divorce are there. There one is talake sunnat. Okay. Revocable and approved. Okay. So this is good way of giving. This is also called good talak. Okay. So don't ask me why it is good talak. Out of the talak is not good for anyone, divorce or talak. But just for academic purpose, what I'm saying, out of all other alternatives, this is talak sunnat, talakul sunnat or talakul sunnat is good one. Okay. So in that one, there are two, again divided into two. Talake Eshan, Talake Hasan. Okay, I'll share this one so that you will have this. So Talake Hasan is most approved. So one pronouncement during tur, purity, followed by 90-day iddat period or abstinence. Okay. So iddat, I'll explain about iddat period. So here iddat means during iddat they will not have sex basically. So 90 days iddat should be maintained. Okay. Then here pronouncement is made, one pronouncement is made and they maintain purity. That is tur or in 90 days iddat is maintained. Then talake hasan. Here 3 pronouncement are made, but there will be a gap. Okay. So today one pronouncement, after 1 month, 30 days gap, after 30 days gap. So 3 times they pronounce talak. So here, before the third talak, he can revoke that. Okay, he will not say that third one. Then it is what we say, it can be revoked technically. Revocable. So, he told 2 times, third time he didn't say. Then it will be revocable. But if he says third time, then it is irrevocable. Talak is completed. Okay. Then other thing is talakul biddat. It is not accepted in India, but it is there in certain countries. Earlier, it was practiced, that is triple talaq. Talaqul biddat is nothing but triple talaq. They used to say talaq, talaq, talaq in a single time. Then it used to be divorced. Okay, in a single sitting, they used to say 3 pronouncement. But it was struck down in Shaira Banu case. Okay, now it is a criminal offense. So now you cannot pronounce those things in a single sitting. Okay. So, and it is a bad thing also. 3 times instant talaq is told. So it is technically irrevocable, cannot be revoked also, triple talaq, but it is illegal and it is punishable in India. It is a criminal offense. Talaq ul biddat. What is that? Talaq ul biddat is illegal. Okay. There is another way, ila. So ila, here husband swears in the name of Allah that he will not touch his wife or her in future and maintains that promise for 4 months and 10 days. Okay, then it is technically is a divorce. Then another way is jihar. See, jihar is a very some thing where husband will say that you are like my mother. It is not acceptable in Muslim law, Mohammedan law. It is not acceptable. Okay, you are like my sister. Okay, so husband compares wife with his mother or sister and in future may not have physical contact for 4 months or more period, then it is divorce. Okay, then there is another thing called khula. Okay, so khula is mutual divorce. So then there is another thing, say lian is there. So here in lian, husband falsely accuses wife of adultery. Okay, and he stays away from her. So, and wife also says she don't want to stay also. So this is also one of the thing. Then another is, if there is another one, okay, yeah, here it is there. Lian is also there. Okay, so khula is there. Khula is divorce given by wife. So she gives up her meher. See, meher is her dower or meher. It is her right. Okay, when husband divorces or when husband dies, they have to give meher to wife. So when in khula, she is ready to give up her meher in exchange for husband consent to the divorce. Husband should say that I am giving divorce to you. So she will ask for the divorce and husband should agree and she will forego her meher. That is khula. Wife is asking for the divorce. Okay, she is asking to release her. Okay, then there is mubarat. Okay, mubarat is mutual consent. Then fasak. Fask, I don't know. Fask, I'm hearing. Judicial. Okay, this is judicial divorce. Okay, this is the first time I asked somebody to prepare, help me. I gave notes, but I didn't go through some certain terms. Okay, fask. Judicial divorce. The wife petitions the court for divorce on specific grounds as provided by law. Okay, this is regular. Fask is a regular divorce. Okay. Lian, I told husband accuses wife of adultery but has no witness. The wife can deny the charge under oath, leading to divorce. Okay, Lian is that. Wife says that I don't want to stay with him because he's accusing me of adultery, and she can retract from the marriage. So on dissolution of marriage, we'll go fast. I think we'll cover some Hindu law also. The wife can sue for judicial divorce also, first on grounds. Okay, first what we told. Okay, I got it. So there are certain grounds where she can sue for on judicial grounds. Husband whereabouts are unknown for 4 years because husband has to give talak, right? So husband is not to be there for 4 years, and failure to provide maintenance for 2 years. So he is not taking care of. See, he may be out of city, he may be having another wife, so he is not maintaining her for 2 years. Imprisonment for 7 years or more. Husband is imprisoned for 7 years or more. Failure to perform marital obligations for 3 years. Okay. Impunity, impotency, insanity for 2 years, or suffering from leprosy or some other virulent or venereal diseases, also she can go for first. Okay, divorce, that is. Then cruelty also is another one. Okay, here option is there if married by guardians. As I told, voidable marriage, if it is married by a guardian, once she attains puberty, she can repudiate the marriage after attaining the puberty if unconsummated. Okay. So maintenance is called nafaka. The husband has the absolute duty to maintain his wife regardless of his financial status or her financial status. After divorce, Muslim law, this is the basic challenge for Saira Banu case. Okay, the Saira Banu case, Muslim law, 128 CRPC, she filed the case. Okay. Here, only during iddat period, the maintenance is paid, but she filed under CRPC Shabanu case where she asked for the maintenance. Shabanu case, sorry, not Saira. Saira Banu is triple Tara. Okay, Shabanu. Okay, so post iddat maintenance to be paid by relatives or Waqf board. This is the act passed actually. Muslim Women Act passed in 1986. This is another important legislation. It should be paid, maintenance to be paid if she cannot maintain herself. Relation or Waqf board should pay maintenance to the divorced woman. Guardianship of the person and property. The father is a natural guardian. The mother is not under Muslim law. Okay. So physical custody of the minor child, the mother has the primary right to custody. Hanafi, son until 7, daughter until puberty, father take custody after that age. So this is another custody. Okay. So children belong to father actually here. Declaration. Okay. A clear and ambiguous intention to make the gift made by the donor. Okay. Ijab. That is, gift is hiba. Gift in Muslim law is called hiba. Hiba. So remember these terms. Basically, if you write it on separate paper, go through them 4 or 5 times, you will understand, because I'm giving you the concept, so you will understand. You can relate it very easily. So a clear, unambiguous intention to make the gift made by the donor. Then there should be an acceptance, that is kubul. The gift must be accepted on or on behalf of the donee. Delivery of our position. The position also should be given. Will. So as I told, one third of the Muslim can make of the total property to outsiders. Okay. 2/3 will remain within the family, inherited to the family only. So a will made under Sunni law, 1/3 made unless his consent is not valid. Okay, if he's donating 1/3 of his property to outsiders, consent should be taken. In Shia law, consent is not required. So inheritance, no right by birth. Inheritance right only open upon the death of ancestor. No one has right to property during the ancestor lifetime. So if the ancestor is there, there is no right. Okay. Class 1 to be fixed specified share includes husband, wife, father, mother, daughter. It is class 1 share. Class 2 residuaries. They take remaining property after the sharers have taken their shares, include son, brother, etc. In most cases, a male heir takes the double the share of female heir. That is very important. Okay, son gets 2x of daughter. If daughter is taking 100 rupees, son will get 200 rupees. You got it? That is the share normally happens. So Iddat is one important thing. So I thought I will talk about it. Iddat, we spoke about Iddat earlier also. Iddat, when a Muslim marriage is dissolved by death or divorce, the woman is required to remain in seclusion for a specified period. During this period, she is prohibited to remarry. So basically, this is only to prohibit the woman to remarry again during this iddat period. So as I told, in Muslim law, the inheritance is very important. Okay. So the iddat period is maintained so that if by chance, if during that period, if she is pregnant, then it will be a problem for the child. They don't know whose child he is. So inheritance issues will come. Okay. So that is the reason iddat period is to be maintained, and she is not supposed to marry during the iddat period. Okay. So iddat of widowed woman is 4 months and 10 days. So So if she is pregnant or not within 4 months and 10 days, they will know that technically. So that is the period they have told. Okay. And for pregnant women, even if she is pregnant at the time of her death of her husband or divorce, till the time of delivery, okay, if delivery or miscarriage happens, even then she has to maintain the period for 4 months and 10 days extra time. So she has to complete that time balance. If let us say delivery happened within 1 month of death or divorce, so she has to continue for 3 months and 10 days. Or if miscarriage happens, she has to continue for 3 months and 10 days extra. Okay. Then iddat of so iddat on talak, not of talak, iddat of talak. Okay, iddat on talak is 3 course of menstruation. If it is iddat is talak is given, then 3 courses of menstruation. Otherwise, 3 lunar months for others. Okay, so for menstruation ladies, it is 3 courses. For others, it is 3 lunar months. So iddat when marriage is irregular. If marriage is irregular and void, no iddat. If the parties have separated before consummation, if the consummation has taken, then wife is bound to observe iddat. Okay. If the marriage is not consummated, iddat has to be observed in case of death, but not in case of divorce. Okay. Even in if not consummated, but it is valid marriage also, but not consummated, iddat has to be observed in case of death. But in case of divorce, there is no need. Okay. The day that begins from the date of divorce or date of death. Okay, this is important, this thing. So this is about Muslim law. Okay.